Welcome to Family Law A to Z with DBD.
Hey everyone, welcome back to an all-new episode of Family Law A to Z with DBD, a podcast from the Pennsylvania-based firm Dischell, Bartle and Dooley. I am your host, Mike Leon. This series reflects the collective experience of the firm's family law team, including attorneys Mark Dischell, Elizabeth Billies, and Katie Lynn Daly, who work closely together to provide clear, practical guidance on the legal issues that impact your family and your future. In today's episode, Katie's going to be joining me because we're going to talk about how Pennsylvania divorce really works, right? Katie's been focusing exclusively on family law, helping individuals and families kind of navigate that divorce process, custody, support matters with a steady client-centered approach. And she's been committed to helping people really understand the process and make informed decisions along the way. So Katie, it's great to see you and welcome you in here to this episode of the pod. So let me ask you at a high level, what does the divorce process entail in the state of Pennsylvania?
Hi, Mike. Thanks for having me today. So if we're talking about the divorce process in Pennsylvania, what we're talking about is a court process whereby a marriage is terminated. Now, on a very base level, a divorce is only the ending of a marriage. There's other ancillary claims that are involved in a divorce. That might be equitable distribution, which is who gets what stuff. That might be custody, who's taking care of the kids, when and how. That could be alimony, pendente lite, or post-divorce alimony, who's paying who what. So at its core, divorce is just ending a marriage. But there's other considerations that we have to take into consideration when we initiate a divorce count.
All of those things sound like it's going to take time. So I'm sure the first question people ask you is, well, how long is this going to take? Like what are some factors that you mentioned a few, but what are some other factors that kind of have the biggest impact that will affect the timeline?
On a super basic level, there's really two timelines that we're talking about. And I'm going to put aside some of the more complicated, more nuanced things like fault divorce. So if we only look at no fault divorce, we're looking at either a mutual consent divorce where both spouses say, yes, I want to get divorced, or you're looking at a divorce where there's been a separation for more than a year. So on a mutual consent divorce, you're looking at a statutory period of at least 90 days. There's no way to shorten that under the law. So the 90 days starts from the date that the divorce complaint is served on the other party, and the 91st day is the first day that you could finalize. Now, if we're talking about separation of a year, you can kind of streamline that process, but obviously you have to have been separated for a year first. So there's a couple different timelines that we could operate under, and it really depends on what your family circumstances are and where spouses are in terms of ending the relationship.
Katie, I'm so glad you mentioned fault and no fault. I would love for you to first off explain and expand out what are both of those and how do the paths kind of differ and how does that choice affect the case? Because you did expand on no fault, but a little bit more on the fault side as well.
Sure. So just to be completely candid, people don't get fault divorce anymore. The new divorce code was implemented in the early 80s, which allowed for a no-fault divorce, either the mutual consent or separation period. And that's really streamlined the divorce process. Prior to the no-fault divorce codes, you had to prove in a court of law that the other spouse wronged you in some way, whether that was adultery, whether that was abandonment, whether that was what was called cruel and barbarous treatment. Those things had to be proven in the court of law, and they had to be proven to be non-collusive. So you couldn't get together with your spouse and say, hey, just say that I cheated on you so that we can get divorced. Those things had to be litigated. And where we are right now is even if those grounds exist, even if there was adultery, even if there was abandonment, when we're talking about proving those things or just being separated for a year, it's easier to just be separated for a year or for both parties to just agree, let's wait 90 days and let's be done with this.
Katie, a second ago, you mentioned a little bit about some of the things that go into the process, right? Like who's going to take the kids, who's going to take the house and stuff like that. And I'm assuming, you can correct me if I'm wrong, that people come to you and they think everything's just going to get decided in court. But in reality, how often are like divorce issues resolved outside of the litigation? And what does that process kind of look like?
So I would say in my practice, about 2/3 of my cases are settled by agreement. So that's either both spouses and their attorneys, or me and one spouse and the other spouse without an attorney coming to some sort of resolution. And what can be kind of frustrating for clients is each of those resolutions, in terms of custody, in terms of equitable distribution, and in terms of support, they're all decided separately. So you can reach an agreement with custody and still not be done with the equitable distribution of your property. Or you can reach an agreement as to custody, but not as to support. So we're kind of incrementally getting closer and closer to an overall resolution without, eating the whole apple at once, for lack of a better phrase.
Right. I'll take it. I like the phrase. Let me ask you, because, we've been talking about all the issues that are at play at divorce. How often do they kind of overlap? Like, how does the process usually unfold when a lot of these issues are overlapping? Like, how does that look?
So, I mean, there's a lot of different ways they can overlap. If one parent has the kids, 90% of the time, child support's going to vary based upon that component. Or if one parent is at home with the kids in the former marital residence, it probably or perhaps makes more sense for that parent to keep the former marital residence. Or, if the marital residence is going to be sold and one party is staying in the same school district, maybe that's the kid's primary house moving forward. It's really, hard to say from a generality. It's so fact dependent and so family dependent. That's why I really try to encourage agreements, because you, as a party to a divorce, or as a parent, your family, your kids, as opposed to having a judge who has met you for 30 seconds before they started talking, and they've never met your kids, or maybe they read an interview of your kids. It's a lot easier, and I find clients are a lot more satisfied when they have a hand in determining what's actually going to happen to them. There's also an element of like safety, I guess I would call it, in saying, I'm making this decision for myself in a way that makes sense to me. Now, a court might say, you have to sell the formal marital home. It has to be sold and you have to split the proceeds. Where if you have an agreement, one party can say, it's really important for me to keep this house. Maybe it's a family house. Maybe it's something that's sentimental to them. Maybe it's been specifically outfitted for them. And you can skew a distribution so that that parent, if they really need to keep the house or really want to keep the house, maybe they're taking less in cash, or maybe they're taking less in retirement. That's where having an agreement can work out better than having to litigate.
Well, Katie, we talked about agreements, but unfortunately, I'm sure there's a lot of people that feel like still entitled to something. Forget this agreement, right? And I'm sure there's misconceptions that you get brought to you about what people are actually entitled to in a divorce. What are some of those assumptions that tend to cause the confusion or maybe even the frustration later on?
So one thing I hear a lot is that, oh, well, it's a 50-50. It's a 50-50 always, a 50-50 right down the middle, 50-50 cash, 50-50 retirement, and everybody goes about their way. And the fact of the matter is that there's 14 equitable distribution factors, which can skew a distribution in either party's favor. So if you have a situation, and this is just an example, where maybe one party earns less money, they're the primary custodian of the children, they don't really have a lot of a separate estate to themselves, maybe they stayed at home during the marriage, that's going to skew a distribution in their favor. Now, another myth that I hear is, if there was adultery, I get more money, or if there was adultery, the other party gets nothing. And that's just a fallacy. That's not true. Marital misconduct is an equitable distribution factor, but it's 1 out of 14. It's not the make or break.
Well, that's good to know. And breaking it down really well there, Katie. Let me ask you, because in a divorce, everyone knows this, the emotions, the timing doesn't always line up with the legal realities that we have to face, right? And you mentioned it a second ago, but how does the Pennsylvania divorce process kind of account for the legal steps and the personal transitions that people are going through during this difficult period?
If we're talking about a mutual consent divorce with that 90-day time frame, I like to use that 90-day time frame to figure out what we're going to do. Is a house going to be sold? Do we need to divide bank accounts? Do we need to maybe move the kids into a new school district? So when possible, I try to plan so that, maybe the house isn't being sold until after a school year. And we're using that 90 days to get all the information that we need and to negotiate to ultimately reach an agreement. On the other hand, if we're talking about a 1-year separation because the other party won't consent, we have a full year to kind of get our ducks in a row and figure out what's going to happen ultimately with a distribution. I do also want to just point out that reaching a agreement in terms of the distribution of property only applies, and I think this, it's kind of logical, if there's property to be divided. If there's, you're in a rented home and you've got leased cars and nobody has any bank accounts or nobody has any retirement, we don't have to reach an agreement at all in terms of the distribution of property in order to finalize the divorce. Now, I do want to kind of just point out that if you raised a claim for equitable distribution when you filed for the divorce, you need to resolve that before the divorce can be finalized. So even if it's been a year, if equitable distribution still hasn't been finalized, that divorce is not getting finalized either.
Katie, in your experience, is that the thing that tends to help divorces move the most efficiently? No conflict as it progresses. Is it like that coming to agreements way before they get down the path?
100%. And oftentimes clients will come to me with kind of a vague idea of what they think a fair settlement might look like. I gather some information, I run some numbers, and we can make a proposal when we send the other party the divorce complaint. Let's just say your wife hired me for a divorce and I send you the nice, "Hi, I'm Katie" letter. This is what we suggest happens with the house. This is what we suggest happens with the retirement. This is what we think a schedule makes sense for the kids. And when we front load it that way, we're just, basically waiting for the 90 days to pass.
Well, let's hope I never get that "Hi, I'm Katie" letter in the mail. Katie, as we kind of wrap here on this episode, let's talk to that person who's maybe at the beginning of this process. Like, what's the most helpful thing that you want them to understand kind of early on about how the divorce process in the state of Pennsylvania works?
So I think the most important thing to think about is the fact that your spouse needs to know. A lot of people come to me and they say, "I don't want my spouse to know. I don't want them to know anything yet." And when you're filing for a divorce, they're going to figure it out. So having the conversation with your spouse beforehand can be really instrumental in getting you to reach an agreement. So you're not getting that "Hi, I'm Katie" letter by total surprise and, getting off on the wrong foot. Sometimes spouses want to mediate first, and I think that that's great. Or sometimes both spouses will want to meet with me with the understanding I can only give legal advice to one person. But, having a 3-way meeting or a 4-way meeting, if the other spouse has an attorney, that is going to contribute to getting an agreement as opposed to bickering about every last thing.
It's great stuff as always. Katie, thanks for the time and the insights. I appreciate it.
Thanks for having me, Mike.
And that's it for today's episode of Family Law A to Z with DBD. If you'd like to learn more about Katie or the team over at DBD, you can visit dbdlaw.com, get resources there that are going to help you explain the divorce process and help you understand really what to expect. Do me one more favor before you head out the door. Hit like, hit subscribe, leave a review, comment, share the episode with someone who maybe is going through the divorce process in Pennsylvania. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.